Your neighbor just installed floodlights that blast straight into your bedroom window. And in most of the country, that's completely legal. Ever wonder what rights you actually have when a neighbor makes your own home unlivable? Today, I'll explain neighbor harassment law like you're 5 years old. By the end, you'll know 4 specific legal tools that most people never find, and exactly when to use each one. Quick note before we start. This is legal education, not legal advice. Laws vary by state and city, so check your local rules or call your local government's code enforcement office. Those calls are usually free, and most offices are happy to answer quick questions. It's 10 p.m. on a Tuesday, and you're completely exhausted. You get into bed, close your eyes, and then it hits. A wall of white light flooding across your ceiling. Your neighbor just flipped on their brand new motion-activated floodlights, the kind that could illuminate a football stadium. And this happens every single night without fail, like clockwork. You can't read, you can't wind down, you can't sleep. Your bedroom, the one room in your home that's supposed to be your refuge, has effectively been taken from you. So you look it up, and here's exactly what you find. In most of the United States, there is no federal law about light pollution. The government hasn't touched this at all, which means it falls to your state, and your city, and your HOA if you have one. And sometimes, your actual neighbor's mood that day. 4 different legal systems might apply to your situation, and each one leads somewhere different. And your neighbor is counting on you not knowing any of them. Let's start with local ordinances, your first and often fastest option. Most cities and counties have nuisance lighting rules. They set limits on brightness, direction, and shielding requirements. Think of it like a noise ordinance, but for light. Your city says you can't blast music at 2 a.m. Some cities say you can't blast 5,000 lumens into your neighbor's bedroom either. These rules are surprisingly common, and most people just don't know they exist. In fact, hundreds of municipalities across the country have adopted some form of outdoor lighting ordinance. Many of them updated in the last decade specifically because LED technology made residential floodlights dramatically cheaper and far more powerful than anything homeowners used before. Your first move, always, is to call your city's code enforcement office, not the police. Code enforcement handles property violations exactly like this. You describe the light, the direction, the timing. If your city has an ordinance, they come out, they measure, they issue a warning. Your neighbor gets a letter that does a lot of heavy lifting for you, and it costs you nothing but a phone call. But what if your city doesn't have a rule, and you call and they shrug? Here's where it gets interesting. Common law nuisance. This is old law, like centuries old. It says, you can use your property however you want, as long as you're not unreasonably interfering with someone else's use of theirs. The key word is unreasonably. A little light spillover from a porch lamp? Not unreasonable. A 1,500-watt security light aimed at your headboard at 2 a.m.? Courts have called that unreasonable in multiple states. People have won actual money and gotten court orders forcing neighbors to redirect or remove lights based on nothing but this principle. No special ordinance required. Just the basic idea that your right to blast light stops where my right to sleep begins. Here's the counterintuitive part. Common law nuisance doesn't require you to prove your neighbor broke a rule. You just have to prove they made your home genuinely unusable. A light so bright you can't sleep in your own bedroom? That's the argument. Judges have heard it. Judges have agreed. And the documented health consequences of chronic sleep deprivation, impaired cognition, elevated blood pressure, increased anxiety, can actually strengthen your case by showing real, measurable harm rather than just inconvenience. Now here's the part most people miss entirely, and this is the moment you need to pay attention. What if your neighbor did this on purpose? Picture this. 6 weeks ago, you filed a noise complaint against them. Or maybe it was a property line dispute. Maybe you sent one letter about their parking. And then, weeks later, 2 brand new floodlights appeared, pointed exactly at your windows. Not at their driveway, not at their front door, at your bedroom. That's called spite. And in some states, there is an actual legal concept called a spite fence, or by extension, a spite structure, that exists specifically for this. The legal test is simple. Can your neighbor explain a legitimate reason for those lights at that angle? If the honest answer is no, a court starts asking uncomfortable questions. The legal term is malicious use of property, and it opens a completely different door. Not just getting the lights redirected, but potentially getting damages. Money. Because they didn't just inconvenience you, they targeted you. A judge does not enjoy that. Your neighbor thinks they're being clever, but what they actually did is hand you a stronger case. Spite isn't a defense, it's evidence. Now, HOAs. If you have one, you might have the fastest path here. HOA rules, called CC&Rs, covenants, conditions, and restrictions, often have very specific language about exterior lighting. Approved fixture types, brightness levels, hours of operation. And HOAs can enforce those rules far faster than a court can. You file a complaint, they send a letter. Your neighbor either complies or faces fines. It's not glamorous, but it works before you've spent $1 on legal fees. If you're in an HOA and you haven't read your CC&Rs, go read them tonight. Search for lighting. You might already have your answer sitting in a document you ignored at closing. Here's what your neighbor is actually counting on. They're not confused about the law. They're betting you don't know about code enforcement, don't know about nuisance doctrine, definitely don't know about spite structures. Their whole strategy is that you'll put up thicker curtains and go quiet. Most people do exactly that. And honestly, that's a reasonable bet. Until right now. So here's what you do. Document everything first. Photos, videos, timestamps. From your bedroom, from your yard, from every angle. You need evidence of where the light comes from, where it lands, and when it happens. If you can, note the approximate brightness. Some smartphones now have apps that measure lux levels, which gives you a real number a judge can evaluate. Then call code enforcement. That one call costs nothing and might end this entirely. Next, send your neighbor a written notice. Text, email, anything with a timestamp. Keep it polite. Something like, your new lights are shining directly into my bedroom. I'd like to talk about adjusting the angle. That message matters later in court. It proves you tried before you escalated. Judges notice that. If the call and the conversation go nowhere, small claims court is your next move for nuisance. You don't need a lawyer. You need your documentation and the legal concept we just walked through. Small claims is designed for exactly this. Two neighbors, a real dispute, a judge who just wants to know what happened. Your photos and timestamps do the talking. And if those lights appeared after a dispute, if there's a clear timeline connecting your complaint to their new installation, you mention spite structure doctrine in a free attorney consultation. One conversation. That phrase alone changes what the attorney sees in your case. Here's the thing about spite structure doctrine that makes it unusually powerful. The burden of proof shifts in your favor. Once you show the lights serve no practical security purpose at that angle, your neighbor has to justify them. They have to explain why 3,000 lumens aimed at your window at midnight is necessary. Most people can't explain that because there is no explanation. There's just revenge. It's 10 p.m. on a Tuesday again. Your ceiling is lit up like noon. And now, instead of lying there wondering if you have any rights at all, you know you have 4 of them. Ordinances, common law nuisance, spite structure doctrine, HOA enforcement. You know the order to use them. You know what documentation you need. You know which phrase changes the conversation entirely. Your neighbor installed those lights thinking you'd just deal with it. And before today, they'd probably be right. So here's my question for you, and I genuinely want to see this in the comments. Have you ever had a neighbor do something that felt specifically calculated to make your life worse? Not a mistake, not an oversight, something timed, something aimed, something that started right after a disagreement? Because the law treats accidental and intentional very differently. And I think the stories in the comments are about to prove exactly that.